All right, class, welcome. Today, we're going to tackle a really crucial and, frankly, a very clever piece of India's constitutional machinery, Article 4. It is the absolute key to understanding how the political map of India can be redrawn with such, well, remarkable flexibility.
So, let's start with a foundational problem that the framers of our Constitution had to solve. I mean, think about it. If you need to create a new state or maybe just tweak the boundaries of one that already exists, how do you design a system that's stable but not totally rigid? You need something that allows for change but doesn't make it so ridiculously difficult that it brings the whole country to a standstill. This was the huge challenge they were up against. Here's our game plan for today. We'll start by really digging into the problem of constitutional gridlock. Then we'll see how Article 4 provides this elegant solution. We're going to get into the legal nuts and bolts that make it work, see how the courts have backed it up, and then we'll wrap up with the key takeaways you absolutely need for your exams. So let's dive in.
Okay, first up, to really, truly appreciate the solution, you have to understand the problem it's designed to solve. So let's look at the potential for total constitutional gridlock that the framers were so keen to avoid. This is really the why behind Article 4.
Just imagine the political chaos for a minute. Every single time a new state like Telangana was proposed, if it needed a full-blown constitutional amendment, well, it would require a special majority. That's 2/3 of members present and voting. And it might even need ratification by half of the states. The entire process would be frozen, just completely bogged down in the highest, most difficult level of constitutional procedure. The country would just lose its ability to adapt.
So, faced with this potential for total paralysis, what did the framers do? Well, this is where the sheer genius and foresight of the Constitution really comes into play. They built in an incredibly elegant solution, Article 4.
This slide just captures the core solution so perfectly. Over on the right, you see the high, imposing fortress of Article 368. That's the amendment process that is difficult, it's slow, and it requires this massive consensus. But then, on the left, Article 4 provides a clear, efficient path. It basically lets Parliament treat a law that redraws the map of India as if it were just any other ordinary bill. It's the express lane.
This analogy is perfect for your exams, so please remember it. Article 4 is the oil that keeps the gears of the Indian Federation turning smoothly. It's what stops the whole system from seizing up when political and administrative realities on the ground demand a change in state boundaries.
So we have this lubricating article that makes everything flexible. Great. But how does it actually achieve this brilliant little shortcut? Let's pop the hood and get into the specifics of the legal engine that drives this entire process.
This is it. This is the single most important clause you need to memorize for this entire topic. Article 4, Clause 2. It's what's called a deeming provision. It explicitly tells everyone, Parliament, the courts, you, me, that a law forming a new state is not to be treated as a constitutional amendment. It's legally firewalled from all those high procedural requirements of Article 368.
Let's just walk through the process. Step 1. Parliament passes a law to create a new state, and they do it using a simple majority. Step 2. That law, obviously, has to change the list of states in the first schedule and adjust the number of seats in the Rajya Sabha in the fourth schedule. Now, normally, changing the Constitution schedules would demand an amendment. But this is where Step 3 comes in. Article 4, Clause 2 acts like this powerful shield, this saving clause, protecting the law from being classified as an amendment and saving it from all those procedural headaches.
Now, this clever constitutional shortcut isn't just some theory you read about in a textbook. Oh no, it is a battle-tested doctrine. It has been repeatedly challenged, examined, and in the end, upheld by the Supreme Court of India.
This timeline shows you the key judicial milestones. And while there were these huge, larger debates about Parliament's power to amend the Constitution, especially in cases like Golaknath, the core principle for Article 4, that it lets you make changes with an ordinary law, that was established super early on and has stayed remarkably consistent ever since.
So the crucial point is this. Sankari Prasad is the bedrock case you have to cite. As early as 1951, the Supreme Court drew a very clear line in the sand. A law passed through the normal legislative process is one thing. An amendment to the Constitution, using that special power under Article 368, that's something else entirely. And laws under Article 4 fall firmly in that first category of ordinary law.
And this is what really illustrates the durability of that principle. Fast forward over half a century later to the Kuldeep Nayar case. The court reaffirmed the whole idea. It confirmed that even really consequential changes, like those affecting representation in Parliament, could be handled through ordinary law if they're a part of a state reorganization, just like Article 4, Clause 1 says they can be.
All right, let's bring this all together. If a question on Article 4 pops up in your exam, this is the condensed knowledge you need to have ready to go.
This table is your evidence. Just look at the history. The massive States Reorganization Act of 1956, the creation of Gujarat and Maharashtra in 1960, all the way to Telangana in 2014. All of them were done using Articles 3 and 4 with just a simple majority. Now, Sikkim is the exception that proves the rule. Its admission involved much deeper constitutional changes. It wasn't a simple reorganization, so that needed the heavy machinery of Article 368.
So treat this as your final checklist. In your answer, explain that these articles work together as a team. Hammer home the importance of Article 4.2. State clearly that this means a simple majority is all you need. Mention the specific schedules that get amended, the first and the fourth. And finally, anchor your entire argument with the Sankari Prasad case. If you can explain these points clearly, you have absolutely mastered Article 4.
And that leaves us with one final crucial question for you to think about. This power is significant, right? Parliament can, with a simple majority, unilaterally change the very map of the country. So what checks and balances, both the procedural ones you find in Article 3 and the wider political pressures, what exists to ensure this huge power is used wisely and not for purely political reasons? That's something for you to reflect on. Class dismissed.